Recording in progress.
Welcome to everyone who's joining us. We'll get started in a couple of minutes. We're just going to leave a little time for additional people to join us. Thanks for being here. Good evening, everyone. Thank you so much for being here. We're going to get started. I know we'll have some more folks joining us, but we're really thrilled to have you and to be together to learn more about the legal work that ACLU of Maine is engaged in. My name is Molly Curran-Rolls, and I'm the Executive Director here at ACLU of Maine. Our work focuses on doing advocacy throughout the courts, through the legislature, and through education and advocacy. And since January 20th, ACLU National and affiliates throughout the country have been involved in over 100 legal actions confronting the abuses of the Trump administration. Here in Maine, our work to champion civil liberties and civil rights has never been more important, but at a time when the rule of law and due process are threatened, we are so heartened to hear how much people are coming out and wanting to get involved in a variety of ways. It's been incredible to see people from across the state, from all walks of life, and from so many different areas want to reach out and get involved and be activated in different manners. So we're just getting started, and we hope that you are as well. We'll have a chance tonight to hear from Erin Rosenblum, who's our Outreach and Education Coordinator, to talk a little bit at the end of our presentation about how you can get involved, different events that are coming up, and different ways for you to continue to work together with us. And again, we're just so thrilled to have you here. I have a short housekeeping reminder for folks who have questions that come up during the presentation. Because we have a limited amount of time, we'll ask that you enter those questions into the Q&A, and then we'll handle them at the end of the presentation and answer just as many of them as we can. Again, if you have additional questions, you can also always be in touch with us after the presentation is over. I want to introduce our legal team. I'm joined tonight by Carol Garvin, our legal director, Zach Hayden, our chief counsel, Anahita Sotui, our staff attorney, Heather Zimmerman, our legal fellow with Skadden, Nell Shea, and again, Erin will be here at the end to help wrap things up. We're really excited again to have all of you, and I'm pleased to turn things over to Carol Garvin to begin the presentation.
Great, thanks so much. And yes, it's so great to have everyone here and to be able to have this discussion. So I am going to start off with talking a little bit about our ACLU litigation priorities and what we're going to talk about today. So always at the ACLU, we have a mix of what I would call more affirmative priorities, things that we have planned for a long time, and then much more responsive emergency casework that is responding to what's happening in the world around us. And right now, for obvious reasons, we have a lot more of that emergency responsive work than we might typically have. So we're going to start by talking a little bit about some of our proactive kind of long-term priorities that we've been working on for a number of years. Most critically, we're going to talk about our case focused on upholding the Sixth Amendment right to counsel. This is our Robbins versus State of Maine case. And this is part of our ongoing sort of long-term priority about focused on protecting the rights of the accused. These kinds of protections are the foundation of our justice system. And so this case is about the right to counsel. We also have cases about, for example, the right to remain silent, the right to be free from unreasonable searches and seizures in the form of unreasonable arrests. So that is one area where we're doing a long-term sort of planned priority case. Then we're going to move on to talk about some of these responsive emergency cases that we have just been developing and filing in the last few months. So one big group of cases are cases that are challenging executive overreach. And that often takes the form of unlawful executive orders. So we'll talk a little bit about our birthright citizenship case, which was filed on the day of inauguration and is continuing right now in the First Circuit. And we'll talk some about a case we recently filed about First Amendment free speech rights, and in particular about how international criminal court sanctions infringe on the free speech rights of activists. And lastly, we're going to cover as sort of the third big category, we're going to talk about some of our emergency responsive work related to protecting immigrants' rights. We'll talk a bit about an ongoing lawsuit we have about challenges to the government's termination of international students' student status. And we'll talk about work we're doing to try to uncover and really understand better what is happening on the ground in Maine in terms of immigration enforcement and how we can respond to that. So that's a little bit of a roadmap of what we're doing today. And I'm going to dive right into our first case that we're going to discuss in some depth. And this is the Robbins case. So the case about that Sixth Amendment right to counsel. So even if you have never set foot in a courtroom, you probably know these words. You have the right to an attorney. If you can't afford an attorney, one will be provided for you. Those words are rooted in the Sixth Amendment to the United States Constitution and in the Supreme Court's decision in Gideon versus Wainwright, which was decided many decades ago. And this Sixth Amendment right to counsel, as Gideon explained really powerfully, that right is essential to a fair trial. it's really what underlies the basic principle that people in our system are presumed innocent until proven guilty. Right now, Maine is failing to meet that basic constitutional responsibility to provide counsel. We are in a constitutional crisis. The state is failing in two different but really related ways. So first, the state is failing to provide counsel for many people at all. So we have hundreds of people in Maine without attorneys at all. Sometimes they are going without attorneys for weeks, even months after they are charged. And many of those people are in jail. And then we have a separate related problem, which is that even when people are being provided counsel, there's a systemic failure on the part of the state to provide the kind of, adequate training, supervision, support, evaluation that is really necessary to ensure that the counsel that people are providing a basic adequate level of representation. So that is the crisis that we are facing. In talking with people in jails all over the state in the now 3 years or so since we brought this case, we have seen firsthand what it looks like when the state doesn't uphold the right to counsel for people in Maine. We've talked with people who have lost their jobs and lost their apartments because they are waiting in jail without counsel. We've talked with people who have been unable to communicate with their loved ones, their family members, people who have missed a child's birthday, people who have been unable to visit a sick parent in the hospital because they are incarcerated waiting for counsel. And all the while, for all of these people, their cases can't move forward. So evidence is being lost, witnesses' memories may be fading, legal investigation and research and motions can't be filed, and they are waiting for their day in court. All the while, these folks know that the prosecutors who brought the cases are bringing the full weight of the state's power against them. But they know they don't have anyone by their side. And so ultimately, we all have a stake. We have a stake in making sure that these prosecutions are carried out fairly, that everyone is playing by the rules, because these prosecutions are brought in the name of the state. And so they are brought in our name, the people of Maine. And so that's why we've been fighting so hard now for a number of years for the Sixth Amendment rights of Mainers. I'll pass it on to Nell.
Hi, everyone. My name is Nell Shea. I am the paralegal here at the ACLU of Maine, and I'm going to speak very briefly about the scope of this crisis over the past several years. In 2019, the Sixth Amendment Center, which is an independent national organization dedicated to upholding, you guessed it, the Sixth Amendment rights of people in this country, released a report on the right to counsel in Maine. Spoiler alert, Maine did not pass that with flying colors. Rather, the report detailed several ways in which the state at that time was failing to meet its obligations under the Sixth Amendment. So we knew 6 years ago that Maine's indigent defense system was broken. That's part of why we brought this lawsuit in 2022, and since then, things have really only gotten worse. While the initial lawsuit was focused on people being denied adequate assistance of counsel, we now have a crisis, or rather have had a crisis for more than a year now, where hundreds of people are not being provided with attorneys at all, as Carol had mentioned. And so this takes me to the graph that you'll see on your screen. Almost 1 year ago, on May 14th, 2025, we released a report using data from the Administrative Office of the Courts on the total number of people who are waiting to be assigned an attorney. At the time it was released, there were 633 people entitled to a court-appointed lawyer who were waiting to be assigned one. That number continued to rise throughout last summer and the fall, and peaked around 800 people in Maine waiting for a lawyer. Since the new year, you'll see that that number has decreased substantially. Still today, there are 350 people without lawyers, which we believe is 358, there were 358 people without lawyers, which we believe is 358 too many. And the average time that those people are waiting for a lawyer is 61 days, or nearly 2 months. It's worth noting that we do believe that drop is at least due in part because of our litigation, and specifically the January 3rd ruling in our case that the state of Maine is violating the Sixth Amendment rights of hundreds of Mainers. And with that, I'll pass it on to Zach to share a bit more about the case.
Hi, everybody. I'm Zach Hayden. I'm a lawyer here at the ACLU of Maine. Thanks so much for joining us this evening. We filed this case on March 1st, 2022. It has been, I think, the most labor-intensive, time-consuming lawsuit that the ACLU of Maine has ever undertaken. We've made efforts over those years to try to resolve the case, to negotiate a settlement. We've had extensive discovery, motion practice, arguments before the court. And finally, it was necessary to bring all of those arguments to the court to have the issue of liability resolved. We did that last fall. We made summary judgment arguments asking the court to decide basically who wins. Are we right that the state is failing to uphold the Sixth Amendment? And if so, what's going to happen to make sure that's no longer the case? So in early January of this year, the court decided that we won. We had prevailed. That the state of Maine was in fact violating our client's Sixth Amendment rights. And, this was a case against the agency, the Maine Commission on Public Defense Services, but also against the state of Maine itself, because as Carol mentioned at the beginning, Gideon versus Wainwright, that seminal Supreme Court case, says it's the state's responsibility to make sure that people have counsel. And in our case, the judge said that right to counsel means continuous representation. So as soon as somebody is informed of the charges against them and has a moment to offer a plea of guilty or not guilty, then they have a right to counsel, and they have a right to counsel that continues through that case. So once the court decided that we were right and that the state was violating the Constitution, the next question was, what is to be done about it? How do we fix this? What sort of remedies are appropriate? So the court had us have a trial on remedies. If you go on to the next slide, in March, we had a 3-day trial in front of Justice Murphy, where we presented testimony from expert witnesses. We presented extensive evidence, and we cross-examined the government. And following that, the judge entered 2 really important remedies. First, she ordered the defendants, the Commission on Public Defense Services, to start providing continuous representation in the form of an injunction, and said that they need to come up with a plan for how they're going to do that. How they're going to fix things so that people have a lawyer as soon as that they are entitled to a lawyer and throughout their case. And then also that people who are locked up in jail, who are being denied their right to counsel, or even if they have, going months with criminal charges hanging over their head, because of those problems that Carol discussed at the beginning, those people were entitled to a writ of habeas corpus. They're entitled to go to have a hearing where they can say, I'm being held illegally, I'm being held in violation of my constitutional rights. This is something that's happened in other cases in other states that have not been able to get their act together with regard to the Sixth Amendment. It happened in Massachusetts and in Oregon. And those hearings are going to happen this summer. We just today got a schedule for the first 2 of those hearings, which are going to start in June. And we're going to travel to Bangor and then to Androscoggin County to have hearings on behalf of our clients, the class members who have been denied their right to counsel. And some of them may get out of jail, may have their charges dismissed. And that's where we're going to go, where things are going to go from here. so that everybody is. Next thing I want to talk about is to change direction a little bit, talk about something that's happening at the federal level, which is presidential overreach and illegal. You heard the Supreme Court argument this morning about one of those orders, but the Trump administration has issued 147 executive orders as of earlier this week, by far more than any presidential administration in history. And for those of you who never took administrative law, or administrative law is a little rusty, an executive order is a way for the chief executive to direct federal agencies, to direct the heads of agencies or the agencies themselves about how to implement a law. They're not statutes, so they're not law in the sense of being statutes, but they are legally binding, which is, a problem when we have a president who is so enthusiastic about issuing illegal orders. But the fact that they're a form of law means that they're challengeable. These are things that we can go to court and challenge them. It's not just the president issuing his, saying something, his opinion about something. They do have some force, and therefore we can go to court and take issue with them when they violate the Constitution, which Carol's going to talk a little bit about one of them, but many of them do. So I'll kick it to Carol to talk about the birthright citizenship order.
Great, thanks. So birthright citizenship, this case was the very first case that we brought after the inauguration of the new president. We brought it that same night of inauguration. And so I'm going to talk a little bit about where that case is. A lot has been happening even just earlier today, as Zach said, in these cases. But first I want to zoom out for a minute and just talk for a minute about the principle of birthright citizenship and why it matters so much. So the 14th Amendment, which was enacted right after the Civil War, is what established birthright citizenship. It ensures in very clear language that everyone born on U.S. soil has U.S. citizenship. And so that's regardless of, the parent's race, national origin, color of their skin, immigration status. There is citizenship if you are born here. The exceptions to this are extremely narrow and really clearly defined. And the 14th Amendment was specifically enacted right after the Civil War in order to ensure citizenship for formerly enslaved people. So that amendment is actually what overturned the Dred Scott decision, where the Supreme Court held that Black people, whether slave or free, are not and could never be citizens. And the 14th Amendment, it essentially guarantees that there isn't a permanent underclass of people, a permanent underclass of non-citizens in our country. So unlike in some other countries, in the United States, if you're born on our soil, then you are a citizen. So this is just a sort of foundational principle of how citizenship works in our country. Moving on to a little bit of how this particular controversy started. So on the day of inauguration, President Trump issued an executive order that purports to end birthright citizenship for babies who are born in the United States on U.S. soil, but are born to a parent with undocumented status or certain categories of immigrants who have temporary status, even if it's lawful status. So this undid hundreds of years of law and precedent. We sued that same day, just a few hours after the executive order was enacted in one of the first cases filed against the new Trump administration. Our legal challenge is on behalf of a group of clients. Our clients are organizations and their members. These are expectant couples in New England, all across New England, who after this executive order was passed, they feared what would happen to their babies who are going to be born in this new world. And they feared that their babies would be deprived of citizenship. So for example, one of the plaintiffs in our lawsuit, they're a couple who arrived to the US in 2023. They applied for asylum. Their application is still pending review. And when we filed our complaint in January, the mother-to-be was in her third trimester, about to give birth. And under this executive order, her baby would be considered an undocumented non-citizen and lose all of the protections that come with citizenship. So in our court complaint, our central argument was that this executive order is a clear violation of the 14th Amendment. And it is also a clear violation of statute, of immigration law that has existed since the 1940s. And it's a clear violation of case law that's existed since the 1800s. So it's really seeking to overturn these hundreds of years of precedent. And so our case seeks both that the executive order be declared unconstitutional and that it be blocked from being enforced. In terms of the current status, a lot has happened in the just couple of months since we filed. So right after we filed, we also filed a motion for preliminary injunction, essentially asking that the court very quickly look at the merits of the case and declare this executive order unconstitutional and block it from going into effect. We had really expedited legal briefing on that. And then in early February, we had oral argument in the federal court in New Hampshire where this was filed. And in a really unusual move, the judge in our case, I don't know, I've never seen this in my legal practice, the judge ruled from the bench granting the preliminary injunction motion. So saying that based on the evidence in front of him, he believed this was unconstitutional and could not go into effect. And so that halted the enforcement of the executive order for our plaintiffs. And the mom that I just mentioned, she then since has given birth to her healthy baby, and that baby has citizenship because that order was blocked for her. But the case has continued. So since that order in early February, a number of things have happened. In particular, I'm sure many people heard, and Zach mentioned, the Supreme Court heard oral argument on this issue just earlier today. And it heard argument on several emergency appeals that are in related cases that are, so not our case, but other birthright cases that is really unusual. These are emergency appeals. Usually the Supreme Court doesn't hear argument on that at all. And here, the court arguments were really focused not as much on the merits of whether the executive order is unconstitutional, but more focused on how can this executive order be challenged. And in particular, the court was focused on whether judges can stop the executive order through a nationwide injunction, which is what several other courts in other cases did. They issued nationwide injunctions to halt this executive order. So the Trump administration in these appeals is arguing that judges should be stripped of their power to use nationwide injunctions to stop unlawful executive orders. And is basically asking the Supreme Court to rule that judges can only block this executive order for the individual plaintiffs, individual states that are directly named in the legal suits. And that would leave many, many families and their babies unprotected. I listened to parts of the argument, and the justices seem divided, but I would say that many of them seem pretty skeptical of the government's position on this. Birthright citizenship, I think a couple of the justices observed, this is an especially odd case that to use nationwide injunctions. As Justice Kagan said in the argument, quote, every court has ruled against you. Every single judge that has looked at this all over the country has found this executive order is unconstitutional. So we will have to wait and see. Probably the Supreme Court will issue its decision on those appeals by the end of June, maybe early July. No matter what the court rules in that appeal, our fight for birthright citizenship is not over. So our case is continuing. It's on a somewhat different track than those appealed cases. So in our case, the government did not go to the Supreme Court, but appealed on the merits to the First Circuit Court of Appeals. And that's where our case is right now. The government's brief is actually due just in a couple of days, and then we'll be responding. So that case is going to go forward, and we will wait to see what the First Circuit says and what the Supreme Court has to say on this. And I will pass it on to the next slide.
Yes, thank you. Hi, everyone. I'm Anna Hijistuhi. I'm a staff attorney here, and I'm going to talk about another one of our executive order cases, Smith versus Trump. So in this particular executive order, the executive order President Trump signed threatens people with really hefty, significant fines or even imprisonment if they provide, and you'll see I'm quoting on the screen, services to or for the benefit of the prosecutor of the International Criminal Court. So to try and sort of break that down a little bit, the International Criminal Court is essentially what it sounds like. It's a court that prosecutes really serious human rights abuses that, for whatever reason, can't or won't be prosecuted by a specific country on their own. That's often true because the abuses, which can include things like genocide and like torture, are being committed by the government or with some gloss of governmental authority. The executive order says that the sanctions and fines are necessary because it declares a national emergency, specifically stating that the International Criminal Court's power to, quote, investigate, arrest, or detain or prosecute U.S. citizens and officials and our allies, that's a threat to national security. It's worth knowing that that's just not true. The International Criminal Court only exists because a large group of countries came together after World War II and said that it should exist. So because of that, it has a lot of built-in safeguards to preserve national sovereignty, and the court can only prosecute people at all after going through considerable investigation and jumping through various hoops. The United States also has a lot of power over the International Criminal Court because of our position on the Security Council in the UN. So the supposed justification for this executive order and the fines and imprisonment and sanctions that it imposes is really not on firm ground. The executive order also purports to be allowable under the International Emergency Economic Powers Act, which we'll get into a little more in a little bit. And finally, the order also says that it is necessary because of the International Criminal Court's purported targeting of the US and Israel. And finally, it's important to know that this is almost identical to an executive order that Trump issued the first time he was in office, and that one was very quickly struck down by the courts. Turning to our clients are two human rights activists who routinely help the International Criminal Court investigate human rights crimes by providing information on human rights abuses and their perpetrators. Matthew Smith resides in Maine. That's why this is a Maine case. He's focused his human rights work on persecution of the Rohingya in Myanmar, and he's identified specific witnesses of specific abuses and connected them to the International Criminal Court. The court needs those witnesses to know what's happening, and also in that case, the persecution is happening in part by the Myanmar government, so there will be no repercussions within Myanmar. This is why we need the International Criminal Court to step in. Ahila Radhakrishnan focuses her work on gendered violence, especially that committed by the Taliban in Afghanistan. And among other things, she has connected the International Criminal Court to victims groups, again, so that they can learn what's actually happening on the ground. Our clients are two extraordinarily brave people. They spend a lot of time in places that you and I would probably not buy vacation homes. And when they're spending time in those places, they spend their time listening to these incredibly harrowing stories of violence. Then they take those stories to people who can actually do something about it at the International Criminal Court. But right now, they are scared of doing their work while they face these potential fines and imprisonment that this executive order imposes. But the good news is that because their work fundamentally involves speech, the First Amendment because it doesn't like what you're saying. But that's exactly what this executive order does. The Trump administration doesn't like the International Criminal Court, so it punishes people who use their speech to try and help the International Criminal Court. That's a crystal clear First Amendment violation. So our lawsuit argues that the executive order is unconstitutional because it has stopped our client's speech based on the content of their speech, violating the First Amendment. We're also arguing that it's ultra vires, which means beyond the authority, because it exceeds the powers that the president actually has under the International Economic Emergency Powers Act. We're asking the court to say that the executive order is unconstitutional and prevent it from being up to date on it. We filed a motion for preliminary injunction. Tomorrow we'll get the government's counter. We then get a few weeks to respond to them, and then the judge will rule. And with that, I will turn it over to
Hello, my name is Heather Zimmerman, and I'm a legal fellow here at the ACLU of Maine. And I am going to move us into our next discussion topic on immigrants' rights, and we'll be talking about ICE activity, due process rights, and wrongful detention. So first, I'll just provide a brief overview overview of this area and our work. The second Trump administration, U.S. immigration law and policy typically takes place following a political transition. This collection of executive actions, memoranda and policy changes have had devastating effects, including attacking the fundamental rights of immigrants and ultimately upending the lives of many of the most vulnerable community members. In response to this chaos, the ACLU of Maine is taking action in a number of ways. Today, we're going to discuss two key areas of our work in this area. First, litigation, specifically challenging unlawful executive action targeting international students. And second, we'll talk about information gathering, about local cooperation with federal immigration enforcement, including both ICE and Customs and Border Patrol, and that collaboration in support of the president's mass deportation efforts. All right, then next, okay, thank you. So I'm first going to talk about a case that we filed against the Department of Homeland Security and ICE, challenging the federal government's abrupt and unlawful termination of international students' F1 student immigration status. As many of you may have seen in the news, this spring, the Trump administration began abruptly terminating the student statuses of international students. The government took this action with no warning at all, quickly issuing form letters to thousands of international students, telling them that their student immigration status was terminated, but providing absolutely no explanation for their action, and importantly, providing no due process at all. International students, of course, are a vital part of our state's universities and our communities, and these abrupt and unexplained termination of student statuses force students to interrupt their studies, interrupt work, and ultimately put the students at risk of detention and deportation. So as a result, we filed a suit against the government. On April 18th, the ACLU of Maine, along with the ACLU of New Hampshire, Rhode Island, and Puerto Rico, filed a class action lawsuit on behalf of more than 100 students challenging these unlawful terminations of their F1 student statuses. The lawsuit challenged the federal government's unilateral unlawful terminations of these statuses, which have had incredibly disruptive impacts on students' studies and lives, including right here in Maine. We challenge the government's action as a violation of due process under the Fifth Amendment of the U.S. Constitution and under the Administrative Procedure Act. As a result of the lawsuit, as well as many other lawsuits filed across the country, this pressure created resulted in the Trump administration announcing a reversal of its position and that it would reinstate international students' F1 student statuses and records. This reversal of action, which happened on April 25th, shows the profound impact that these lawsuits can have on the administration and its unlawful actions. However, even after the administration's reversal, much uncertainty remains for these students impacted by the government's action. So we are continuing to litigate this case to be sure that the government's decision to reactivate student statuses remains stable and will apply to all of the students that were impacted by these decisions. Next, I'm going to hand it back to Anahita to discuss our information gathering.
Yeah, thanks. So like Heather mentioned, another way that we work in this area is by gathering information, and we do that for a few different reasons. One, Heather was mentioning earlier that this administration's immigration-related agenda is really based on creating fear. Part of how they create fear is by being really opaque and making it hard to know what they're doing. So by gathering information, our goal is both to help educate people and try to address that fear at least a little bit. We also hope that once people know what their government is doing, they can react to it by haranguing their elected officials or by protesting. So turning to specifics, there are major questions still about how immigration enforcement in Maine works or doesn't work. We've heard from community members and advocates that a lot more immigrants are being detained in Maine than before Trump was in office, but without much more detail about where they are and how long they're staying there or under what authority they're being held. And then separately, we've also learned from local news and other community members that a few towns in Maine were going to enter into formal agreements with ICE, and we wanted to know what exactly they were agreeing to. So we submitted public records requests in an effort to address both of those information gaps. We do that from the federal government under the Freedom of Information Act and from local government under the Freedom of Access Act. And Zach is going to start us off by talking about some of our federal government work.
Thanks, Anahita. The Federal Freedom of Information Act is one of the most powerful tools that we have for doing our work. And as Anahita mentioned, it helps us learn more about what's going on. It helps us make sure that the government knows that the public is paying attention. And it also helps have us all be informed so that we can exercise our democratic prerogatives. So we've been using the Freedom of Information Act, that's the federal open records law, to get information about how the federal government intends to cooperate or collaborate with local law enforcement. For example, we were reading through the minutes of the jail authorities in Maine, which is something we get to do as ACLU lawyers, and noticed that last July, at the Two Bridges Regional Jail Authority meeting, there was a presentation by Immigrations and Customs Enforcement about plans that they had for using local law enforcement and working with local jails and local sheriffs. So we asked for a copy of that. As you can tell from this presentation, we love PowerPoint. This is a PowerPoint presentation. We said, perfect, we'd love a copy of that to see. We also have asked for all of the agreements that Department of Homeland Security has entered into with Maine jails. Those are called intergovernmental agreements, or IGAs, and we're in the process of requesting or trying to get copies of all those IGAs and also intergovernmental service agreements, which are called IGSAs, between the U.S. Marshal Service and any of the Maine County jails, so that we can better understand what their plans are, not only what they're doing now, but what are their plans for in the future as they work to expand enforcement and removal operations. And I think I'm going to pass to Heather to talk a little bit about some of the local requests.
Thank you. Yeah, so next we'll look at local requests that we sent to the Maine sheriffs. And coming into this as background, we started getting reports, as Anahita mentioned, about more immigrants being detained in county jails across the state. And these reports raised multiple legal questions and concerns related to the relationship between local law enforcement and federal immigration agencies, the authority being used to detain these people, and the detention conditions where they were held. So in late March, we emailed all of the Maine sheriffs with requests for information. Some of the sheriff's offices, however, failed to respond or only provided partial responses. So next we turned to the state's Freedom of Access Act, FOA, to request information that the remaining counties hadn't provided, continuing to push for more information about how these county jails were detaining immigrants. Most recently, we received a response from the Franklin County Sheriff's Office. I will just mention that all of this information is available on our website, again, because of the importance of getting this information to the public. We're particularly concerned with learning more and understanding what's happening in Franklin County, because since early March, the Franklin County Detention Center has detained 66 people, holding these individuals for multiple days with no criminal charge, but instead simply listing the individuals as held under a Border Patrol hold. Through our FOIA request, we learned that the sheriff's office in Franklin County has no agreements with the federal government. So this leaves real questions about what authority the jail is using to detain these people. We're continuing to push for more information from Franklin County and others using FOIA. I'm going to hand it back to Anahita now.
Thank you. So we're going to turn to 287G agreements. I can see from the chat that some of you are already familiar, but I'm just going to ask you all to bear with me while I provide a little bit of background. So 287G is a federal law that lets ICE enter into contracts with local law enforcement that can be at the town or county level. And under those agreements, the local police department agrees to carry out some of ICE's immigration enforcement work for ICE for free. These agreements raise any number of problems. One is that they allow local law enforcement, and I'm going to quote from one of the agreements, to interrogate any alien or person believed to be an alien as to his right to be in the United States. We have serious concerns over how any police officer will determine that they believe someone to be an alien, and that it can mean police will interrogate anyone who just looks or sounds like they don't belong, and that will in turn result in racial profiling. These agreements are also bad because they can be incredibly expensive. They commit the local police to doing quite a lot of federal immigration law enforcement without any reimbursement from ICE. We know that is a really severe problem because across the country, other towns and counties have had to withdraw from their 287G agreements or have actually had to raise property taxes to cover the cost of them because they are so expensive. So our requests on this topic have focused on 2 towns in Maine after we learned that they were going to enter into these problematic agreements. We wanted to know what the agreement said and how ICE had communicated with the towns about the agreements. So starting with our first request, which was to Monmouth, Winthrop. They are 2 towns, but 1 police department, which is why we got 1 request. After we sent them our records request, they got really significant public pushback and ultimately decided not to pursue the 287G agreement at all, which is great. They did give us some of their internal communications about the agreement, and those communications really emphasized one of our concerns. They explained that they wanted to enter into this agreement because right now, when their police officers pull someone over for a broken taillight or some similar other minor traffic infraction, and that person turns out to be an immigrant, the officers will just wait with that person roadside for hours and hours until ICE or CBP can show up and take the person. That can be really concerning. It's possible that they're overstepping the bounds of what they're allowed to do. It's also possible that they're not. It's frankly a really complicated question that depends quite a lot on what happened in each of those individual instances. So we're sending them another request to try and find out a little more about what's happening when they're doing that sort of thing. We also sent a request to Wells, which had actually already entered into a 287G agreement. Wells gave us a copy of their agreement, and that really confirmed all of our suspicions and in fact raised more concerns. We learned that they entered into this agreement less than a month after learning that it existed. As far as we can tell, this was a really haphazard, rushed decision that didn't allow for a lot of public input. That's really concerning because in Winthrop and Monmouth, when there was public input, the town knew that the community didn't like it and decided not to enter into the agreement. But the people of Wells didn't have that opportunity beforehand. We also learned that their agreement does have the problematic language that permits interrogation of suspected non-citizens. And we also learned that the training the officers are going to get under this agreement is really laughable and completely insufficient. Since then, Wells community members have pushed back really significantly, and the town is currently considering whether to withdraw from the agreement, which they can do very easily. So we're continuing to work with community members who have organized to protest the agreement. We're also working with the legislature to support a bill that would make it impossible for towns in Maine to enter into these agreements with ICE. And with that, I will hand it off to Aaron.
Hi, my name is Aaron Rosenblum. I'm the Engagement and Education Coordinator here at the ACLU of Maine, and I'll give you a little bit more context about our work and then talk about how you can get involved in what we do. So everything we've heard so far is from our amazing legal team and our executive director about the work they do in the courts and the information gathering they do, but that's not the only way that we work. So another big part of what we do is policy work by our policy team, and they're in Augusta nearly daily working on there are more than 2,000 bills have been introduced in this session, and they're tracking as many as they can and supporting the ones that help secure and expand our constitutional rights and opposing the ones that do the opposite of that. And then another part of our work is our work in the community and community engagement. So we are working with students, and we are at public events, and we're at rallies, and we're doing Know Your Rights trainings, and doing what we can across that legal and policy and engagement work to further our goals and hopefully yours. If you'd like to know more about that, you can stay up to date with us by going to our website, aclumaine.org. We've got a email list. It says get our updates at the top. You can put in your info and start receiving our periodic emails. You can also follow us on Blue Sky, Facebook, Instagram, and Twitter. On all of them, we are at ACLU Maine. If you'd like to take action, also on our website, there's a Take Action button. And from there, you can contact your legislators about priority issues that we've identified. There's also a bill tracker showing which of those more than 2,000 bills we're weighing in on and whether we support or oppose them. And it links out to the state's bill tracker as well. So you can really get into the fine details if you're interested on any of those bills. Some of the action items we have now are on protecting trans rights in the law and data privacy in the law and speedy trial, upholding the right to a speedy trial. If that sounds similar to what you're hearing about tonight, it is. So our legal team is working on Sixth Amendment rights in the courts, and our policy team is working on that right to a speedy trial, which is related in Augusta, trying to create proactive laws that help make that possible. So when we have a goal, we look at the ways we can work across our organization to achieve it. And another thing that you can do on our site, and I encourage you to do, is visit the Know Your Rights section. We have multiple formats of information there. We have things written out in text. We have videos. We have printable pamphlets. Many of these things are available in multiple languages there on the website, including the videos and much of the text. And the topics covered in our Know Your Rights information include ICE and law enforcement encounters, knowing your rights when protesting, knowing your rights when traveling, and a sort of newer one is knowing your rights when informing other people of their rights. So that's become a popular topic and a question we're getting a lot. People want to be sure of their ability to let other people know about their rights. I learn something new every time I visit that part of our website, and I think I've read all of it, and then I learn something new anyway the next time. So visit, learn things for yourself, and please share all of that information. It's there so that people can learn about it. You can also support our work. There is a donate button conveniently on our homepage. We can't do this work without you. We don't receive any government funding. On the upside, we can't lose our government funding. And also on the upside, you can help us do this work. So you can make direct tax-deductible gifts to our affiliate. You can join the National ACLU and become, like nearly 6,000 other Maine people, a card-carrying member of the ACLU. You can give a gift membership. You can give a gift in honor or in memory, which is my favorite way to give. And you can look at planned giving, which I am not ready to do personally, but it's probably never too soon to think about. That's probably what a financial advisor would say. So please take a look and support the work if you can. And you can also join us and come find us in the community. We have more and more public programming coming up. You'll see through the summer and fall. A couple places will be soon. Next week, we will be at the Portland Public Library in the Teen Library. So if you are between the ages of 12 and 19, come see us. That's the Teen Library is specifically for folks 12 to 19 to have their own space. So if you are an adult or a small child, we'll catch you at a different event. For instance, we will be at 3 Prides this year. We will be at Hallowell Pride on June 7th. We'll be at Portland Pride on the 21st and Bangor Pride on June 28th. And we'll be back here on Zoom in early July for a term in review of the current Supreme Court term. So a lot of big cases are before the court right now. We should start seeing decisions hopefully in the coming weeks, and with any luck, they'll finish their term on time around the end of June, and we'll be able to give you this same legal team on some in-depth analysis of what has just been decided and what the impacts are going to be. For more information on all of that, to find out about events as they're being added, again, follow us on social media, sign up for our emails, check the events page on our website. So I'm excited to toss it back to the legal team for some of your questions. I'll be the voice of your questions. We'll also drop them in the chat. And I'm going to start with one. We have a couple questions on law enforcement and immigration enforcement. And I think I'll pass it to Molly, because this bridges into our policy work as well. The question is, what is the possibility of preventing local law enforcement from doing immigration enforcement? And related, we're combining questions here, what really are sanctuary policies, and are they effective in this scenario?
Thanks, Aaron. Thanks for the question. I'm going to stand in for our policy team. I want to share a couple of things. The upcoming next week, we'll be hearing both LD 1259 and LD 1971 in front of the legislature. The public hearing will take place at 1 p.m. And both of these pieces of legislation are designed to address what Anahita was talking about, the issue of 1287G agreements and the broader issue of the use of local law enforcement to really collaborate in ways that make them a part of ICE and would make this concept of a mass deportation push really possible. This is something that we're seeing across the country, often referred to as part of a bundle of sanctuary policies. That can mean many different things in different contexts, but often these types of policies do include pushing back on 287G as a initial issue. And we know that it's really important, as Anahita mentioned, for Maine resources to be focused on Maine needs, and for us to really be talking to the legislature about the impact of these kinds of agreements, which we're continuing to learn more about all the time. As we think about sanctuary policies, Zach, I'm wondering if you want to speak to this. The question of a definition comes up quite often. And again, there really isn't one specific thing that sanctuary policies means. It's usually all kinds of things that are designed to both support immigrant communities and help ensure that local resources are used for local needs and for local folks. Oh, if anybody else wants to jump in. Carol, I don't know if you want to say anything about this either. I think Anahita gave a great overview of both the issue and why we're so involved. If people would like to, there'll be opportunities to provide testimony both in person and also remotely. And we will be there providing testimony. And you can check out our website for more information about both the bills and also our concerns about these agreements. When I hear the word preventing, working together with between local law enforcement and federal law enforcement, that is not something that we can stop, right? So there are legal mechanisms and appropriate mechanisms for local law enforcement to work together with federal law enforcement with appropriate warrants, with appropriate relationships. What we're seeing in this instance is really operating outside of any kind of regular legal structure and looking for a level of work that's collaborative in a way that we would not support.
Yeah, this is Zach. I'm sorry, just as you asked me a question, kick the question to me, Molly, my AirPods died. It's
oh, no
one
problem.
of those days, and many of those days, actually, where by 7 o'clock, the technology starts to take a rest. What I think is important with this is that our law enforcement, local police work for us. They should be responsive to the needs of the community. And part of the challenge for us all is to activate our, not only thinking about things at the presidential level, but thinking about local government and how we can demand that our local government be responsive to the needs of the community. And this is a perfect example. I know that I saw in some of the chats about how Wells activists are pushing back, other communities, people are pushing back against some of this work. And I think it's very inspiring.
Yeah, thank you. I know we have at least one person here from Wells. Thank you for the work that you've been doing. Heather mentioned also the impact on communities who, may not feel that it's safe for them to seek support from law enforcement or seek support from the emergency room, or may feel that it's not safe to go out and access school or go to work in a normal way when these policies are in place. So, what we want to be focusing on when we talk about local needs is what can we do to make sure that our neighbors can feel as safe as possible and can pursue their lives and their livelihoods in ways that are supported.
Great. We have a bunch of great questions. I think we'll definitely try to get to a few more and keep an eye on the time. Hopefully you all can hang with us for some of these great questions, especially if you asked one. We'll try to get to it. So we have a couple questions about plans. We have a Project 2025 outlined plans to limit government transparency and FOIAs. Are there constitutional or other protections that could stop that in court?
I can just mention, yeah, so I think in terms of the FOIA obligations, if there were an effort to limit the sort of responses, and I think, honestly, I think we're already seeing that. I think of many of the people whose job it was to respond to FOIA requests have lost their jobs. And so there's sort of a slow walking of that already happening. And I have to say, this is disturbing because even at full strength, responses to FOIAs are very slow. That is never a fast process. So we're in sort of the slowest of the slow. So yeah, we've certainly in the past, even under other, even at other times when we don't get a prompt response to FOIA requests, then we are ready to go to court to enforce those rights. It's a really important law that does have real specific requirements for the government in terms of responding. So that's, there's certainly avenues for going to court if we just don't get responses or don't get timely responses, or what we're seeing, I think, and we'll continue to see, we get kind of partial responses, things are blacked out, they're claiming privilege on a lot. All of those are things that we can go to court over. If there was an effort to actually repeal the whole FOIA statute, that would be a different thing. And so then we wouldn't have that tool anymore and we would have to really evaluate differently. But that's, so far, I think what we have seen is not any congressional effort to get rid of the law. It's really this much more sort of under the radar, just slow walking and claiming privilege or redacting things when it really should be produced. So I think there are avenues to challenge that in court.
Great. We have a question about the Robbins case, and that is, what reasons is the state giving for why so many people are denied the right to counsel? And I think anyone working on that case could answer, and I would even add in, has that answer changed across the multiple years of this case?
There have been so many answers. I think all of us could give you a, dramatic reading of the government's explanations over the years. But some of it has been arguing about when people are really entitled to lawyers. There was an argument for a while that if you have a lawyer at your arraignment at the time when your charges are read against you, and then don't have a lawyer for a while, and then later get a lawyer for a plea negotiation, and then you don't have a lawyer for a while, and then maybe then have a lawyer at a trial, that's okay. That's an okay way to do it. The judge in our case said that's like a jack-in-the-box lawyer, and that's not what the Sixth Amendment requires. There's always a lot of finger pointing. One part of the government will say, no, it's their responsibility. It's the court's responsibility. It's the legislature's responsibility. This is something, unfortunately, that comes up in our case, in our litigation all of the time, where people in government refuse to accept responsibility for what they're supposed to do. Helpfully, though, we have this very well-established Supreme Court precedent, Gideon versus Wainwright, that says it's the state's responsibility and the state wants to figure out how to meet that responsibility, it can, but it can't avoid that responsibility.
Great, thank you. I think we have time for maybe one more. There are a couple more, but I think we want to make sure we respect everyone's time and let you get about your evening. So we have a question about habeas corpus, and I am going to pre-select Heather and Anahita to answer this, but anyone can jump in, obviously. But I've learned a lot about habeas corpus from Heather and Anahita personally, and so has everyone at the ACLU of Maine. So the question we have is, what is habeas corpus, and what are the implications of the recent government threats to, quote unquote, suspend it?
I can talk a little bit about what it is, and if I could tell you the implications, whatever. We'll get into that too. I can tell you a little bit what it is. So habeas corpus is basically it's a type of legal action, and what you're always arguing is that this person is detained in some way. So they might be in jail, they might be in prison, they might be in an ICE detention facility, and they shouldn't be. The fact that they're detained is illegal, and so they should be released. That's the sort of big picture of what the legal case actually is. It can come up in various different ways. There are different arguments if you are being detained before you were convicted of a crime versus afterwards. But that's the big picture of what it is. Implications of suspension, if someone else would like to take that, that would be great.
I can take this. I love talking about habeas corpus. And its suspension. So so habeas, I mean, it's one of those things that I think we learned about in law school, but it's sometimes felt academic. It is now underlying. I mean, many of the cases we talked about today are actually habeas cases. So our Robbins case, the remedy we have is a habeas corpus remedy that people who are illegally detained without counsel should get released. They shouldn't have their liberty restricted. The Mahmoud Khalil case is a habeas case. The illegal detention, if people are illegally detained based on unlawful cooperation with ICE, that those can be there can be relief through habeas. So it's a hugely important tool. It actually goes back way before we were a state, before we were a country. That it dates back to like the Magna Carta and before. It's basically this underlying principle that when the government interferes with your liberty, there needs to be a way to quickly challenge that and say, I am being unlawfully detained and my liberty is being restricted unlawfully. And so in general, there's actually a really clear provision in our federal constitution and in our state constitution that say you have a right to habeas corpus. And it's called the suspension clause. And it says that right cannot be suspended. So it's very clear. And the only time it can be suspended is in times of unlawful invasion. So, it's really, these threats, I think would fly in the face of both our state and our federal constitutions. And if somehow that did occur, it would undermine all these different avenues for relief in just a whole range of cases. But I think there's, very, very strong legal protections. I mean, you can't get stronger than it was in the Magna Carta. It's in the federal constitution. It's in the state constitution, that it can't be suspended. So yeah, we'll keep our fingers crossed on that one.
Great, thank you. I just want to shout out something that has been discussed in the chat a little bit for folks interested in those two bills, LD 1259 and LD 1971. And Molly may have said this part too, and then it came up in the chat again. The hearing on those is May 19th at 1 p.m. in the Judiciary Committee. And if you're interested in letting your legislators know how you feel about it, please do. We have a question about volunteering in the Q&A as well. And I would just say for that, you could head to our site, undertake action. There's a volunteer button there, and you can fill out a quick form and get that to us. And we're just getting going again with our volunteer programs, but hopefully we will get back to you. So thank you for that question as well. And we are a bit over time. So I would like to offer the entire panel the opportunity to unmute and say thank you exactly simultaneously, or everyone stay muted. And I will say thank you all so much for coming. It's been great to have you all here learning about this. We hope to continue to engage with you and offer you more updates, more information. We look forward to seeing you in the community and your support. Anyone else have any great parting messages? Okay, well, thank you all so much, and we will see you next time, I hope.